Welcome to This Explainer. Today, we're diving straight into an absolutely fascinating high-wire act, the delicate balance the Philippines performs between its own absolute domestic power and the broader rules of global governance. It's this high-stakes interplay between national sovereignty and global interdependence, and we're going to break down exactly how it all works.
So it's a brilliant question to start with, right? How exactly do global treaties or customary norms or even UN declarations actually transform into the everyday rules that govern the Philippine state? Well, they don't just magically appear in the local rulebook out of nowhere. There's a very deliberate, structured legal filter that turns these global concepts into domestic reality.
Here's our agenda for today. 1. The rules of nations. 2. Two doors to local law. 3. Jurisdiction and state immunity. 4. Navigating law of the sea. And 5. The Sovereignty Balancing Act. Let's get right into it.
Section 1. The Rules of Nations. Understanding hard and soft law. The foundation of it all really comes down to Article 38 of the Statute of the International Court of Justice, which basically defines where our international obligations actually come from. Now, what's really interesting here is how the Philippine framework draws a strict line between two categories. First up, you have your hard law. These are your binding treaties and conventions, firm, written, signed agreements. Then you have soft law, which includes things like declarations from the UN General Assembly. Now, while soft law isn't strictly binding on day one, over time and through consistent practice by states, it can actually evolve and harden into binding customary law. Pretty cool, right?
Moving to Section 2. Two doors to local law. How the world enters the Philippines. The Philippines operates on what's called a dualist tradition. That just means international law and domestic law are treated as two separate systems. So how exactly do we bridge that gap?
Well, the first door is the doctrine of incorporation. Think of this as an open door, literally built right into the 1987 Constitution. Article 2, Section 2, flat out declares that the Philippines adopts the generally accepted principles of international law as part of the law of the land. This means customary international laws seamlessly become local law. They don't need Congress to pass a new bill. The Constitution itself has basically already rolled out the welcome mat.
But while incorporation is that open door for general principles, the doctrine of transformation acts a bit more like a strict bouncer checking IDs at a club. For specific treaties, that hard law we talked about, to actually become domestic law, they have to be transformed. Under the Constitution, a treaty requires the explicit concurrence of at least 2/3 of the Senate before it takes effect locally. No vote, no entry.
And the Supreme Court completely nailed down this distinction in the Pharmaceutical and Healthcare Association case. They explicitly drew the line. Transformation requires domestic legislation, like that Senate vote for treaties. Incorporation, on the other hand, means the norm carries the force of domestic law by constitutional declaration alone. If you want to see this doctrine of incorporation in action, you really just need to look at landmark cases like Kuroda and Majoff. In those instances, the Supreme Court ruled that fundamental human rights are a part of Philippine law, even if the country hasn't signed a specific treaty detailing those exact rights. Why? Because they're generally accepted principles of international law, so they just walk right through that open door of incorporation. It's a massive safeguard for basic human rights. All right, Section 3, Jurisdiction and State Immunity, the limits of local power. Once a state actually establishes its laws, we have to ask, how far does that power reach, and where does it absolutely hit a wall? A state exercises its jurisdiction based on 5 main principles. You've got territoriality, which covers the physical borders, nationality, following its citizens, protective, which covers state security, universality, which targets really heinous crimes against humanity, and passive personality, relating to a victim's nationality. But despite all this immense domestic power, it hits a hard limit when dealing with other sovereign nations. And that crucial limit comes down to the Latin maxim, par in parem non habet imperium. Basically, equals have no sovereignty over each other. This is the absolute bedrock of state immunity. A local Philippine court can't just drag another sovereign nation into a trial without its consent, because on the global stage, they're equals. It's exactly why foreign embassies and diplomats generally can't be sued in local courts without their home country saying it's okay. Let's jump to Section 4, Navigating Law of the Sea, harmonizing UN clause and domestic waters. This is where all this high-minded legal theory literally meets the physical geography of the Philippine archipelago. To make global rules work with local laws, the framework is split up.
On the global side, the 1982 UN CLOs dictates the big picture, things like the territorial sea and the exclusive economic zone. But domestically, the Philippines makes this work using statutory demarcation tools, like the Baselines Law and the newer Philippine Maritime Zones Act. These domestic laws translate those broad global standards into local, actionable blueprints.
And this brings us to a really critical piece of jurisprudence, Magalona v. Ermita. The court stepped in to clear up a huge public misconception here. They clarified that domestic baselines laws absolutely do not acquire or diminish territory. Actually, they're just statutory tools used to draw lines on a map to demarcate maritime zones. Real acquisition or loss of territory is governed by general international law, not just by passing a local baselines act.
Which brings us to our final piece, Section 5, the Sovereignty Balancing Act, National Power versus Global Interdependence. This perfectly captures the friction between a nation's absolute domestic power and the unavoidable reality of living in an interconnected world. Engaging with international treaties really puts the domestic separation of powers on display. The executive branch, with the president acting as the chief architect of foreign policy, is out there negotiating treaties. But the Senate acts as a vital check on that power. Remember that bouncer analogy from the Doctrine of Transformation? Yeah, without a two-thirds Senate concurrence, a newly negotiated treaty is simply not becoming domestic law.
And the true conceptual climax of this whole framework is the paradox of auto-limitation. You know what, you might be wondering, why on earth would an independent state willingly follow rules made by the UN or the WTO? Well, it's because true sovereign power actually includes the ability to voluntarily limit yourself. By giving up just a tiny fraction of absolute power, like, say, agreeing to specific trade tariffs, the state gets the massive reciprocal benefits of an ordered global system, economic cooperation, and international peace. It's a trade-off, but a necessary one.
So, now that we've mapped out exactly how international rules become domestic law, what should we explore next? Should we unpack maritime disputes under UNCLOS, maybe take a closer look at international human rights enforcement, or try to untangle the web of state immunity? The global stage is officially set, and the choice is yours. Think about it, and I'll see you in the next explainer.